In the news today, we hear about our government going bankrupt, trillions in debt, and people losing their jobs. In today's case, it wasn't about that, but her pregnancy was the problem. She was fired from her job because her pregnancy was a problem, not her performance, but her pregnancy. So your hook is this like, hey, government's bad, we can't get anyone a job. This is an action about labor law, and pregnancy was her problem, was alliteration, that's your theme. All right, another example. One more example on the hook theme combo. Take a quote from like the defendant. He said, I'm gonna go get him. I'm gonna get my brothers and I'll be there tomorrow. Those words came from his mouth. And this case is about 3 men, 2 guns, and 1 mission. Okay. Start the quote. I'm gonna go get my brothers, I'm gonna go get it, right? Your theme, 3 men, 2 guns, one mission, all right? So that's a way to take a theme, or take a hook, some sort of popular saying, something in the news, and then go into your theme. That theme you're gonna repeat over and over again. The hook, you're just gonna kind of leave it there to the very, very end, okay? So the hook's just a one time at the beginning, we're gonna talk about it maybe at the very, very end. Your theme is something you're gonna say over and over and over again. So once you got your hook and your theme, then say what your case is about in 2 sentences. Just tell them real up front. This is a case about a robbery where a man broke into someone's house and he took her jewelry. And 3 days later, he pawned that jewelry and we have a pawn ticket to prove it. At the end of the day, it's a pretty simple case. That's it. All right, 3 sentences about what your case is all about. Sum it up for him, put it up front, and then you're going to come back later and kind of give him some more detail. After that, I want you to briefly say who you are and briefly say what side you represent. I mean, brief. My name's Zeke Ford, and I represent the state of Texas. That's it. My name's John Smith, and I represent the plaintiff, Miss Mary Alice, right here. That's it, okay? Just kind of focus the jury. They might have got a little bit lost. Which side is this guy arguing for? So you're going to tell them up front who you are one more time. Give them your name and who you represent. Whether they're the plaintiff or the defendant, whether they're the state of Texas or the state of Nevada or whatever fake city you're in, or the defense counsel. You often call your client by their first name, like, this is Quinn Chase, my client, because that's a personalization of them. You call the other side by plaintiff rather than their first name because it makes them seem less appealing. All right? So that's your first kind of paragraph. There's your introduction there. All right? Go hook, theme, 2-sentence summary, an introduction of yourself and your client, and you're done. Then you're going to go to the burden of proof. If it's a civil case, what's your burden of proof? Somebody.
Preponderance of the evidence.
Thank you, sir. Preponderance of the evidence. You can say that one time, and that's enough. That's a legal jargon term. I don't want you to say it again. Preponderance of the evidence. Tell them what that means in layman's terms. I mean, in layman's terms, preponderance of the evidence means 50-50. If one side has 51%, they win. It's like a scale. All right? 51 percentage. You can put in all sorts of stuff. In a criminal case, burden of proof is beyond a reasonable doubt. That's a legal term. What does it mean? If you believe it in your gut, probably beyond a reasonable doubt. I mean, talk in layman's terms so tell them what it is. The judge is going to tell you that in this case, the burden of proof is a preponderance of the evidence. All that means is 50-50. If it's 51%, we win. All right? So tell them the burden and tell them who has the burden. If you're the plaintiff or the prosecution, openly and freely admit, we have the burden in this case, and we've met it. By golly. And if you're the defense, say, they've got the burden over there, and they didn't meet it. So that's the whole second paragraph I want you to think about, is the burden of proof, who it is, which side you represent, whether it. One thing else you want to do that's really popular, especially in criminal cases, is to tell about the elements. You can also do it in civil cases. The elements of a crime are, it was this person at this location, like this defendant in Collin County, Texas, on this day, robbed this person. Those are the 5 elements. The only thing at issue in this case is it wasn't this defendant. He had a mask on his head. So we're going to talk a lot about everything in this case, but if there's only one thing at issue, let them know that the only issue in this case is identity. This lady really did get robbed. There's no question about that. She really did have this stuff stolen from her. The only question is who did it. So in a civil case, if it's duty, if it's negligence, your elements, duty, breach, causation, damages. In this case, the only thing this trial is about is damages. Was she injured? Was there injury? Whatever the issue is. And so you're going to kind of have to make the issue. You have to think about, in this case, what are we really fighting about? We're fighting about identity, we're fighting about value, we're fighting about causation, and tell the jury that these are all the elements we've got to prove, but the only thing that's really an issue is X. That's what's at issue here. All right. Once you have the burden of proof is where you really get to the meat of your argument. It's only like a short bullet point, but in the quantity of your closing argument, this is where the meat is. And I have two different organizations, depending on if you're the plaintiff or prosecution, or if you're the defense or defendant in the case, just the way you kind of do it. Let's say you're the prosecution or the plaintiff. You kind of want to talk about your case. This is where you go back. You told them this is about an old lady who got robbed, who came in her house and stole the jewelry, and now you kind of back up. And you say, you tell a story. Say, remember what Miss Jones said when she was on the stand? She had gone to bed that night after watching Law and Order, about 10 o'clock. And when she woke up, because her dog started barking, remember that dog started barking, and she said it was at the back door. Well, you'll remember that the neighbor across the fence, he also testified. He testified that he heard her dog bark at about 11 o'clock, and that dog never barks. So now you start telling a story, and you start incorporating the witnesses who have testified in your fake trial. So remember what the characters are in your case, or your memo that you had. Think about, they've testified now. That's how you got this information. They've testified, and you want to retell that story. So as the prosecution or the plaintiff, you're going first. You want to tell that story, and you want to tell it like a story. I think you should talk like you're talking to a fifth grader. Okay? That's probably the average intelligence of a Dallas County jury. So the thing is you have to communicate to everyone. So if there's 12 people on your jury, you don't know their ages, you don't know their background, so you're going to talk like it's a fifth grader so everyone understands. So tell a story like you're telling a buddy at the bar, like, oh, dude, you won't believe this. Don't say dude. But you can say, you won't believe what happened to her that night. You know, just like you would tell a friend or something like that. Go through some exhibits or documents if you have those, if you think about it. Like, remember that photograph? Like this photo, you can hold it up, or that map. If it's important, you can kind of go through your evidence and go through your witnesses who testify in your trial. Once you've kind of gone through your story, then you kind of play to the other side and rebut their story. That's the second part. You say, oh yeah, but they got up here and guess what they said? He got his mom on the stand as his alibi. What's mom going to say? Mom's going to vouch for her son. We all know that before she even said a word out of her mouth. So you can start discrediting their story, discrediting what they said, discredit, if there's an inconsistency in their argument. Now, you're not going to have a real opponent. Like, you're just giving your one side of the argument. So you have to kind of think about what they would have said, or what they would have argued during their trial. You know what their issue is. You know what their stance is. So just rebut it. But use real language. Don't use attorney language. If you're on the defense side, you should flip-flop those orders, okay? If you're on the defense, that means the prosecutor's already been up there and said this guy's guilty, 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 this is why, all these people testified. And you want to get up and say, oh, the state thinks it's so easy. You know, they put this police officer in his uniform, he looked real nice. But what about he didn't say this, and he didn't say that, he never interviewed this person. So if you're on the defense, I think you discredit first, and then come back and talk about your case. Be like, but what we brought you was this alibi. Johnny was at work, and he's got his ticket from his paycheck that day. So, I mean, if you're on the defense side, I think just the organization is a little bit different. You first rebut their story, and then you tell your story. So it's a little bit different just on the organization of the facts. But this section is where you're just telling a story, and make it sound interesting. Make people want to know what happened next. And finally, you go to the end. You can literally use that first paragraph you wrote and jumble up the sentences and come up with your end, okay? Because you're going to do the same thing. You're going to tell your case in 2 sentences. This is a case about a robbery. Where she was broken in, her home was broken into at night and jewelry was stolen. Or where this lady was fired for the wrong reason. She was fired because she was pregnant. That's not allowed. Okay? Whatever your issue is, just tell it to them in 2 to 3 sentences. Reference your hook or grab. Remember, in this economy, jobs are tough. And when people get fired because they're pregnant, that's not right. I mean, that's all you have to do, just a slight reference to that first thing you started out with, okay? Go back to that hook, reference it, and then repeat your theme one more time, really firm, and then tell the jury what you want. Find the defendant guilty. Find Dr. Pepper liable. And when you put how much, put 100%. Whatever yours is, I mean, that's where you end on. Be very clear of what you want them to do. Guilty, not guilty, liable, not liable. I mean, that's kind of where you're at. So be very, very clear. That's kind of the organization of how you give a closing argument and what I think is a good outline for you to start putting in things, plugging things into. Is there a right or wrong way? No. You can do whatever you want. That's why trial work is so much fun, is because there's not a lot of rules. And you get to talk, and you get to have some personality. But what I want to give you now some tips about all that sort of stuff I gave you of how to kind of incorporate that thing. I want you to use normal people language and not lawyer language. Let me give you an example. A lawyer would say, well, subsequently there was an altercation. Right? Those are big lawyer words. A real person says, afterwards there was a fight. Okay? I want you to say there was a fight. Don't use words like, oh, the altercation resulted in the injury of my client. No. My client got punched and it hurt. Okay? That's what you want to do. You want to talk to real people, so don't use legal jargon and legal terms. If you need to explain what something means, like negligence means this, give it, you can say it and give it to them in layman's terms. All right? That's what you want to do. That's what your job is to explain the law in normal, everyday, 5th grader type terms. And that's what I suggest you first tip. Second tip, act like the 13th juror. I mean, again, I'm a little bit cheesy and a little bit, I don't know, folksy. But I don't mind saying, folks, we know what happened here. Or y'all, or we all know why she's not telling the truth. Remember when I asked that question, we all saw her squirm on that stand, and she didn't want to answer that question. Remember when we saw that? If you say we, you're acting like you're the 13th juror sitting right next to him. And if you say, folks, this is about justice, and we need justice in this county and in this state for this person who got wrong. So folks, we, y'all, I think it's really endearing. I want it to be genuine though. Don't like put on a honky tonk if you're not. If you are, go for it. I think you'll be really successful. So be genuine in who you are, but talk like you're the 13th juror. Remember that it's we saw this. In this trial, we saw this. We saw this gun or whatever. Say we. And it puts you as 13th juror. Use analogies. One of the best ways you can argue is to use an analogy. So if you say, it's kind of like you saw a kid with some chocolate on his face, the candy jar was empty, and the wrapper was in his pocket. He's guilty of eating that chocolate. And in this case, we got all the ducks lined up too. We got this, we got this, we got this. So use an analogy when it's appropriate, or use an analogy to prove a point. That's allowed, okay? And use a real-world example that people might be familiar with. Because again, you want to connect to your audience. When you're going through your summary of facts, kind of like talking about, this witness testified to this, and this witness testified to this, and this diagram showed this, I say recap, don't rehash. A rehash is just this play-by-play, like you were a sports commentator watching it over and over again. They sat through the trial. Okay, they're a little bit smarter than you think they are, and they probably remember some of it. So just talk about the high notes. Don't go through every detail. I think a lot of times people get lost in the details, so I would avoid, unless they're important, avoid dates and times, like and street names. It doesn't matter. Like, it was her street in the evening hours on that night. I don't care that it was 9:53 on a Thursday night on 123 Elm Street. That doesn't matter. So those things are kind of distractors. So just recap the high points and use rhetorical questions. Rhetorical questions are really effective when you want to recall the testimony. So you can say, remember folks when that doctor got up on the stand and testified, the cause of the death was the stab to the abdomen. Remember that? And remember when he put up that diagram of what we saw? The knife was still stuck there. So if you ask them to remember or to recall or something like that, a rhetorical question, or like, what did you expect Mom to say? Mom got up on the stand and she was his alibi witness, but we knew she was going to say that, right? What did you expect Mom to say? So ask them a rhetorical question